Yes.
From the
127 not becoming.
Oh, अच्छा.
from the Delhi project on the heading for orders will defect. Item number 1, PA number 19 of 2018, Mr. Piyush Padar for the appellant, Mr. Rahul number.
All these matters will go before another bench. Brother will not hear. Item number, all of them to be tagged. All of them to be tagged against the same. For common for different assessment years.
Block assessment.
Out of the same order of ITSU, there are 4-5 assessment years, they are going to back.
Let tax appeals number 2 to 7 be tagged together as learned counsel for the appellant, Mr. Mahendra Chaudhary, submits that they arise out of the common impugned order relating to block assessment against the same SSC appellant. Stop. However, let the matter be listed before a bench of which one of us within bracket, Deepak Roshan Jay, is not a member. Wait. First tagged with item 1.
Item 8, LP number 39 of 2022, Mr. Sasank Sekhar for the appellant.
Corona is again increasing. Figures are again starting. So in this matter, we are nothing to say because one matter has been withdrawn. एक छोटा सा request करने के लिए because there was a cost.
Cost we have not waived in that consciously because the RNC. We did not say so. No? Withdrawal of an appeal does not preclude filing of a review petition.
Yes.
That you very well know.
Just to save face of another.
So we will record your submission that you want to make a prayer for review. Limited to cost. No, but we cannot say that he should be limited to cost. It is his submission. His submission only we will record. His submission will. Petition, this appeal is the same.
At page number 227.
What is the number of that LPA?
38 of 2022. 38 of 2022.
So this writ petition arises against WPC 6 of 22.
Yes.
This appeal arises out of a common impugned judgment dated 31st January 2022, passed in writ petition civil number 6 of 2022, referred by respondent number 1 hearing, and WPC number 157 of 2022, referred by the appellant hearing.
Yes.
Stop. Latest patent appeal number 38 of 2022 was preferred by the same appellant Ranchi Municipal Corporation, being agreed by the same judgment as regards dismissal of their writ petition WPC number 157 of 2022. Stop. The said appeal has been withdrawn by the appellant on instructions. By learned counsel for the appellant on instructions. Stop. A wide order dated 8th March 2022. For easy reference, the order dated 8th March 2022 is extracted hereunder. Stop. Para. Learned counsel, senior counsel for the appellant submits that appellant may be allowed liberty to seek review of the impugned judgment so far as the imposition of cost of rupees 20,000 on the appellant is concerned, concerning passed in respect of the writ petition civil number 157 of 2022. Now that appeal is not before us. No? This is the other appeal, Mr. Sajid.
Yes, saving up, क्या बोले? अब समझ गए? मेरे ही तरफ के other side is also here.
Learned counsel for the appellant submits that permission may be granted to withdraw this appeal. Just reframe the sentence. Learned counsel, senior counsel for the appellant submits that permission may be granted to withdraw this appeal on instructions, however, with a liberty to move before the learned writ court for review of the impugned order so far as it relates to imposition of cost of rupees 20,000 on the appellant herein. Stop. Appellant, it is open for the appellant to do so if permissible in law. Stop. The appeal is dismissed as withdrawn. Pending IAs are closed.
Further orders. Item 9, Civil Review number 89 of 2018. Mr. Bhaiya B. Pradeep Kumar, Court of Petition.
On the last occasion, directed me to decide how someone will be served from the
Yes.
The comment now deciding at Singapore, and then one provision order 5/2025. It says, where the defendant resides out of India and has no reason in India, power to accept service. The summons can be addressed to the defendant and addressed where he is residing and sent to him by post or by such. Courier service and may be approved by the High Court by fax message or by electronic mail service or by any other means as may be provided by the rules made by the High Court. If there is postal communication between such place and a place where the post is situated, provide where any such defendant resides in the address of Pakistan. In that case, the respondent will be residing at Singapore.
So, you you had taken steps for service of notice on respondent on a given address at Singapore also.
Yes.
But the report received from the High Commissioner's Office, Singapore, says that no such person resides at this address. Therefore, on the last occasion, we asked you to either find out the correct address of the respondent or to suggest the alternative method like paper publication, etc. But we do not know whether वहीं पर है कि
अभी तो पता नहीं है।
at best, since he last resided at Singapore, so you can seek a paper publication in Singapore.
Yes, sir, I can take one, but my client has gone to Singapore to verify their police property and their police residing.
Then you need more time.
Sometimes it may not like because since last day, I'm trying to contact him. But he perhaps she is working in some company.
And where is this appellant residing nowadays?
Now he is residing at night.
He was earlier himself residing at Singapore.
Yes.
Any, then counsel for the appellant seeks an adjournment. Stop. Matter is adjourned for 3 weeks, 4 weeks.
Item 10, first appeal number 9 of 2021, Mr. Ispidai for the appeal.
The maternal grandmother has been allowed.
No, husband.
Acha Rahmatullah Ansari. And who is the appellant?
Appellant is the
Divorced wife. She is still having the custody.
Right.
And why have you not filed the affidavit which we asked? Then we will direct the custody to be handed over to the respondent because you are not obeying the orders of the court. नहीं वो आपको 2 बात पर एफिडेविट बोलने कहा गया था.
Medical checkup, source of income, or budget status of education of money.
Education, हाँ. So you should have filed it.
हमको रेगुलेट करेक्ट.
अच्छा, you are respondent. Where is the appellant? Who was appearing? Mr. Purnendu Sharma. The order dated 23rd December 2021 has not been complied by the appellant. Stop. No one represents the appellant today. Stop. When counsel for the respondent husband has got a decree for custody of the minor children in his favor, but the physical custody of the child still remains with the appellant. Stop. Accordingly, both the appellant and respondent are directed to appear on the next date. Appellant should comply with the order dated 23rd December 21 by filing necessary affidavit at least 3 days, desired affidavit at least 3 days before the next date. This is the case on 5th April 2022. Both appellant and this. Appellant should appear with the minor children. Let the learned counsel for the respondent, Mr. Manoj Shah, shall inform learned counsel for the appellant, Mr. S.P. Roy and Mr. Purnendu Sharan of today's order by tomorrow. Yeah, Monday.
For admission, item 12, TA number 9 of 2019, Ms. Amrita Sinha for the appellant.
In this case, on the last occasion was directed to seek instruction. However, instruction has been short for, though it falls below the monetary limit, but there is an exception with respect to that organized tax evasion. And circular 23 of 2019, there is an exception is there. So it can be heard on merit. I received the instruction, I could not file it on an affidavit or to be direct, I will be filing it on affidavit. The instruction which I received.
You are for respondent. You file an affidavit to that.
I will be filing.
That controversy will go.
I will.
Then counsel for the
You should have
appellant.
made that question of law in your, that is this serious issue, no?
The question of
Supplementary
law.
question
Question
of law.
of law as to how it falls within the exception.
I will be.
You
I will
file
be
a supplementary
filling that
question of
question
law.
of
Bring it on record.
Bring it on
I
record.
will be filling that question.
Because organized tax evasion is a term of wide interpretation. Not 2-3 person have clubbed together and did
Generally,
some.
it is involved in matter related to
EDVD
68, addition under section 68, wherein the share premium, share chain are going, money are being rotated among the people only.
But that question of
In a
law
big, not 3-4 persons.
should stem out from the materials on record
Factuals,
Yes,
concerning this SSC.
I will be framing a question of law in this respect.
law.
When counsel for the appellant prays for and is allowed 2 weeks' time to file supplementary affidavit. Stops. He submits that the when counsel for the appellant submits that the appeal is maintainable as it falls within the exceptions of the circular number 23 of 2019. Stop. She prays for and is allowed 2 weeks' time to file supplementary affidavit to that effect and also incorporating any additional
I required then. In IES the amendment will be, so it is better that IES will be filed.
IEA/supplementary affidavit incorporating additional substantial question of law which may arise. Yes.
Item 30, TA number 40 of 2019, along with item number 14 and 15, Ms. Amrita Sinha for the appellant.
In all these matters related to 234 AP, Your Lordship, I have not received the instruction as in yet, Your Lordship. I observed, so that I sent a reminder to that extent also, but I have not received. Although the monetary limit is very less, Your Lordship, in these cases.
So much less.
Yes, Your Lordship. There are about 4 lakh rupees in one case.
So, are you in a position to state?
One time is one more opportunity to given, Your Lordship, because it is difficult to withdraw in such manner.
And counsel for the appellant pays for one more indulgence to seek instruction as to the maintainability of the appeals on the question of monetary limit. Stop. List the case, as prayed for, list the case on 24th March. All these appeals.
Item 16, LPA number 412 of 2020. Mrs. Lisa Santita for the application.
Password.
Item 70, WPT number 3619 of 2020. Mr. Nitin Kumar Prasad for the petitioner along with item number 18.
Your Lordship has circulated an email yesterday for journals in this matter, Season 17 and Figure 18. The journal has to be filed with Lordship, but it is not be filed as applicable to not be known.
What is the stand of the respondents as to your prayer for adjustment?
Your Lordship, they are contending that the amount for which we are seeking rectification in the form, that one is the penalty amount which cannot be adjusted, the other is the amount of interest which was for different period. So that is not be adjusted. We file a detailed refund as well.
And counsel for the petitioner. Petitioners in both the writ petitions praise for an adjournment, praise for time to file rejoinder affidavit. In 17, only rejoinder is to be filed. 18, you have already filed the rejoinder.
Yes, sir.
Praise for time to file rejoinder in WPT number 3619 of 2020. Stop. Pleadings are complete so far as WPT 3671 of 2020 is concerned. 2 weeks' time as paid for is allowed. Is the case thereafter. Other side, Mrs. Ranjan Mukherjee, AC2, Mr. P.S. Pati. We'll come to your case 1920 after few other matters. In 21, also you are appearing, Mr. Garodia.
Yes,
And the Commercial Taxes Tribunal is now functional. So, so this writ petition can be disposed of. Anyway, ask him to come so that we can pass any order in his presence.
Item number 21, WPT number 4377 of 2020.
उसी के बारे में उसको भी पास होना चाहिए.
Item 22, TA number 16 of 2021, Mr. Rahul Lamba for the appellant.
Yes, I've seen it.
Issue notice. File the. देख लेते हैं. How much is the,
Tax effect is 1,269 lakhs. 846 in the table under fifth column.
yes. Issue notice on the respondent under registered cover with heady and speed post for which requisites be filed within
1 week after the meeting.
1 week after the opening of holy holidays. Stop. Appellant shall also effect service notice on the official email address of the respondent containing the attachment of the memo of appeal and its enclosed annexures within the same time and file a supplementary affidavit to that effect within 1 week thereafter.
Item 23, first appeal number 40 of 2021, along with item number 24, Mr. Arvind Kumar, Mr. Ashish Kumar Sekhar for the appellant.
So this 18,000 to 9,000, he is asking for increase and you are asking for decrease.
My submission is that my lord is sent to mediation for final settlement. Because there are a lot of criminal cases also pending in this item. So together for 5 cases.
What happened? What happened to the matrimonial main suit? Achha. Divorce in favor of the husband. 20th June 2018. Reference may be made to the order dated 2nd March 2022, which reads as under. This is for the benefit of the mediators. Will they understand me?
In the meantime, I request that they are not taking any maintenance even after the order dated 11/1/2019, and in the gap of litigation, they are not taking any.
Mediator.
They have only paid 10,000. The area is about 6 lakhs 66,000.
You file an affidavit showing proof of the deduction. Learn counsel for both the parties. Submit that the issue may be resolved through mediation at Jhalsa, where parties are willing to appear physically. Stop. Parties are divorced since 20th June 2018. It's only a question of the amount of maintenance which has been modified by the impugn order passed under section 25(2) of the Hindu Marriage Act 1955 by the Learned Family Court, Bokaro. Stop. As such, let the parties appear before the Learned Member Secretary Jhalsa after Holi. They have to come from Bokaro on 23rd March 2022 at 10:30 a.m. Stop. He can be approached on the following numbers. On their appearance, matter be placed before the learned mediator for undertaking the exercise. Parties are expected to cooperate in the mediation proceedings and attend with an open mind and attend each of the sittings. Stop. Husband shall pay a sum of rupees 1,250 to the wife on each date she attends the mediation, towards the travelling and incidental cost on each date she attends the mediation proceedings, in the presence of learned mediator Jhalsa. Stop. If the parties are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature and be submitted along with the report 4 weeks thereafter. Stop. Let the matter be listed in the week of 2nd May 2022 along with the report. Stop. Learned counsel for the wife submits that the maintenance amount are due in huge areas. Stop. The counsel for the husband shall file an affidavit containing proof of the payment of the maintenance amount from the date it is ordered. At least 1 week before the next date.
Item 26, WPT number 3133 of 2021, Ms. Sima Kumari for the petitioner, Mr. P.S. Pati for the respondent.
Who is for the service tax? Mr. Pati? You see, you can demonstrate all these explanations by filing a reply before the adjudicating officer who has issued the so-called notice. That whether the additional director general DDGI is competent authority or not, whether you are covered by the exemption certificate notification of 1st March 2016, all these things you can demonstrate.
The prima facie shows that we are exempted.
So, ठीक कर सकते हैं इनको को लेके आप
The text are supposed to be presented because on behalf of
so where is Mr. Ratnesh?
DGC.
ADGP,
Yes, DGC.
His name is not appearing. The file must be with your office.
it is with my office also and it has been over because he.
Respondent number 2 and 3 are, 2 is your,
Yes, Your Lordship, but ADP is the respondent number is represented by the police. I'll just inform him, just pass on the one case and.
you inform him to be here. One more case, Mr. Mittal, the last one. Thereafter, your cases.
I don't basically have to say anything. I have said whatever I said and I have
No, no.
taken notes also. I don't have to say anything.
No, we will take up after next item, item 20.
Item 28, WPT number 1008 of 2022, Mr. Nitin Kumar Pasari for the petition.
So 6th, 18th April.
18th of April.
Give the order sheets. This is the short order.
Yes, Your Lordship.
You have the first order.
Yes, Your Lordship.
Here also 29th June. What is?
Yes, no, this date is 7/4/2021.
Okay.
7th April 2021.
ये पेंसिल से करेक्ट कर रहे हैं 7th April 21 date of notice.
Period involved 17 April.
Huh?
Assessment year involved 10 to 17 April.
Relating to AY 2017-18. Where is that main order? Same order, इसमें with necessary corrections. नहीं, एक sentence लास्ट में लिखिए. Let the, or it will naturally come because it is being tagged. Tagging order is already there here also. We will further say let it appear on 18th April 2022 when other analogous matters have been posted. और ये 26 हाँ 16 ये wait. Mr. Mittal, please wait. There are few passed over matters which. So, Mr. Prabhat has not come.
But I informed you that he is coming.
Anyway, so we take up item 16, which is a passed over matter. Mrs. Rita Sanchita is here. Not yet. Then supplementary list का read.
From the supplementary for read under the heading for admission, item 1 WPS number 4944 of 2017. Mr. Mukesh Kumar Mehta for the
Respondent advocate Mr. Kumar Sinha आपको स्टेशन है क्योंकि को छोड़ने जा रहे थे घटना तो एक्सीडेंट हो गया कल की बात है
What came in this session? Additional number 2 has died number 2. 1 2 is time. Total morning and information.
You are Mr.
Mukesh Kumar.
So yes, yesterday Mr. Prem Mardi said. No, Mr. Prem Mardi stated that he will. No, he said that he will argue. So he can't be anywhere else when the case is taken. But since the P2 has died, we will adjourn it for his substitution.
I will argue. I will.
Very well.
He is associate counsel.
Mr. Mukesh Kumar Mehta, Land Counsel for the petitioner, submits that petitioner number 2 has died during pendency of the writ petition. Stop. Therefore, time may be allowed to carry out his substitution. Stop. Land Counsel, Miss. नहीं आपका नाम Ganga Kumari submits that Land Counsel for the respondent, Mr. Vijay Kumar Sinha, has met with an accident on way to Patna. Therefore, the matter may be adjourned. Stop. For both the reasons, the matter is adjourned for 3 weeks.
2 weeks matter is very important.
Substitution petition be filed. No, application seeking substitution should be filed at least 4 days before the next date of hearing.
4 different matters. Petitioner is working in different places.
Kindly hear the order.
You were asking for 2 weeks. We are giving 3 weeks.
3 weeks.
And
4
we are
days
asking
before the next date of hearing.
I'll answer.
Kindly have patience.
at least 4 days before the next date of hearing. So, list accordingly. अच्छा
Negative.
bottom.
Usi line.
Yes, next, item 16, council is not there.
Item 16, LPA number 412 of 2020, Mrs. Disha Sansita for the applicant.
Pass over. Mr. Ratnesh Kumar is also not there in item 26. ज़्यादा स्पीड में चल रहा है।
नहीं और
Item 26 में नहीं।
कॉपी ही नहीं हुआ अगर कॉपी होने से तो नहीं रहता
आज हम देखो तो वो काउंटर पे लगा।
हाँ तो उसी बड़े चंदा लेते हैं विशाल में कॉपी
हाँ।
ओरिजिनल में तो
What you do is to serve a copy on Mr. Ratnesh Kumar also. Because today, even if he comes, he may not be aware of. Mr. Pati, you are also there.
As for the respondent, the show cause is issued by the respondent.
So cause is issued by respondent number 1 and you have been asked to adjudicate. Or the jurisdictional assessing authority has been asked to adjudicate.
But they are essentially against the show cause notice.
Basically, SCN is under challenge.
Yes.
So, actually, we thought of asking counter affidavit from both of you, and meanwhile asking him also to appear and file their reply before. Because if this adjudicating officer is satisfied with the reply, then we may not have to adjudicate it.
In primary ground, he has raised is that the agreement registration was not required. That doesn't stop the section 29 of the Stamp Act thereafter provides that if, section 3 says that government will be liable in case in such cases when the government is liable, then it is not, this agreement is not to be signed. Now, then again section 29 of the agreement, which says that the onus lies on whom for the stamp duty. So he has to make out a case, not a case that there were no facts, jurisdictional fact for issuance of the show cause notice. It is the issue in its adjudication, whether the document was required to be stamped, and if required to be stamped, on whom the onus lies. So it is not an issue that is settled or requires no factual adjudication. So it should go before the authority.
Is he coming, Mr. Ratnesh? Is he in the court or? शुरू से उनको क्या बोलना है हम पहले से जाने जो करना है 2 मिनट करना है गेम्स हो गया और जो 2 मिनट करना है पहले हो गया तो डिटेल वाला
पहले भी देखते हैं ऊपर नीचे होता था उसका लास्ट में
Second proviso is for the Indian Stamp Act, section 3, provided that no stamp duty shall be chargeable in respect of any instrument executed by or on behalf of or in favor of the government in cases where, but for this exemption, the government would be liable to pay the duty chargeable in respect of the instrument. That is in a case that if you have stopped the section would start there that no duty will be chargeable, then no adjudication is required. Now the second part requires adjudication. Whether it was required to be stamped, then it required to stamp, whether the onus was on the government, then this case will stand. So it is not a case where the show cause is without any basis or without any jurisdiction or the foundational facts don't exist. Those facts require formal adjudication. No. My humble comment is not a case of caution of the very show cause on this one. We have informed him.
let us see the Stamp Act.
My lord, I may not be able to assist your lord's right.
We are enriching ourselves since we have enough time. Council is also on the way.
Madam, I must tell this, section 29 now says that owners will lie on. I was doing some research. 29 specifically does not deal with this situation of agreement, whether specific entry with regard to agreement and the owners is not specifically mentioned there. I also doing some research.
They are relying upon the notification issued under the Finance Act.
Yes, that's it. If duty is paid.
Hmm?
That says if duty is paid, in that case the instrument will be valid. And that's a that notification. Page 4 of the petition is themselves. However, the above position was provision was limited by notification dated such and such dated 1/3/15 with effect from 1/4/15. This benefit was then restored by Finance Act 2016 notification dated such and such retrospectively with the condition that the contract for construction, erection, commissioning, installation, completion, fitting out, repair, maintenance, and renovation should have been entered prior to 1/3/15 and on which appropriate stamp duty where applicable has been paid prior to such date. So this part is causing the trouble. The notification and what I understand is that this part is causing some trouble for us. That appropriate stamp duty where applicable has been paid prior.
Their agreement is of before 1st March
Yes,
2015.
agreement is 28/7/2007, 7/3/2012, and 26/2012.
Do they say
And the
that?
period of demand is October 14 to March 17.
Do they say that stamp duty was paid on that earlier?
Pardon?
Do they say that stamp duty was paid?
No, they make out the case that it was not required to be stamped at all. They are basically placing reliance upon section 3 and saying that the purpose of this part of the notification is only to ensure that there should not be any anti-dating to take benefit of this exemption clause and nothing more and nothing less. So, my agreement was a non-judicial stamp paper. Transactions are admitted to prior of that date. So, my case cannot be said to be of anti-dating in any case. And this part, on basing your finding on this part, the authorities are not correct to reject my case for exemption that I was not licensed to sell. And the second argument is raised about limitation, that extended period of limitation will not apply. These are twofold arguments that he has raised for portion of the issue.
Stamp Act नहीं है.
So I have
Stamp act, sure.
this.
Stamp act.
Keep a copy.
For the second proviso of section.
एक बार कम से कम आप लोग बीच में आए. You are referring to the liability of instruments through duty.
To section 3, second proviso. Yes, it's only one provision. Section 3 proviso provided that no duty shall be chargeable in respect of one, any instrument executed by or on behalf or in favor of the government in cases where, but for this exemption, the government would be liable to pay the duty chargeable in respect of such instrument. So, my understanding is that the instrument is not required to be stamped or duty is not liable to pay. If the owners of the duty, payment of duty will lie upon the government. Now, who is liable to pay the duty is again provided in section 29. That in what category of documents who will be liable to pay the duty.
So, by the person drawing, making or executing such instrument, his instrument will come in which category?
I could not find a specific entry over here. Need some more research.
The SC?
Is the 700, then B, C, and C and D, E, F, G also is not.
The notification of 1st March 2016 has not been annexed in the writ petition.
They simply annex the show cause notice and the plea agreement.
The notification on which you are relying, you have not annexed. You have only annexed the SCN and three agreements.
But then you file it and meanwhile you can also start copy upon Mr. Ratnesh Kumar because I believe there.
We are prima facie of the view that they should appear and file the reply.
Yes, but meanwhile that will be also ordered that meanwhile they will appear. Because ultimately if your lordship are satisfied the show cause notice for everything will go in that case. Adjudication will take
And
some time.
if the adjudicating authority is satisfied that yes, they have
That also very
that also can be possible. Otherwise, unnecessarily, it will keep pending here and they will also not take any action. And proceed. Then counsel for the petitioner undertakes to serve copy of the writ petition, copy of the pleadings on Mr. Ratnesh Kumar, who appears for the DDGI/respondent number 1. The arraignment of the respondents is also not in the proper manner, isn't it? It should be the authority institution first and then. Which counsel is going to argue from outstation? From Patna?
From Delhi.
Delhi. Stop. By tomorrow, please, and file a receipt in the registry. Stop. Learned counsel for the petitioner also undertakes to file supplementary affidavit to bring on record the notifications dated 20th June 2012 and 1st March 2016 upon which reliance has been placed. Stop. The name of Mr. Ratnesh Kumar be reflected in the cause list henceforth. उसमें एक सेंटेंस ऐड करिए मिस्टर उसके ऊपर में सर्विस यहाँ लिख रहे हैं मिस्टर रत्नेश कुमार एक्सेप्ट्स सर्विस ऑन बिहाफ ऑफ द DDGI सर्विस ऑफ नोटिस ऑन बिहाफ ऑफ द DDGI स्टॉप मैटर बी लिस्टेड ऑन Agreed. 30th March 2022. Stop. फिर लिखिए. The show cause notice dated 27 December 2020 issued by respondent number 1 is under challenge. Though
Notification 25.
On the ground that it is without jurisdiction and in teeth of the exemption under which exemption by notification dated 1st March 2016 क्या लिखा है?
So-called notice dated 27/2000 is under challenge on the ground that it is without jurisdiction and in teeth of the
being issued by respondent number 1 additional director general DDGI and in teeth of the exemption notification dated 1st March 2016 whereunder petitioner a government undertaking was not liable to pay stamp duty for agreements entered prior to 1st March 2015. Stop. Is the case on so and so date. Meanwhile, petitioner shall submit its reply before the adjudicating officer. What is the date given as per the SCM? In that case, we give a longer time, and you.
Condition would be that if he is required to file any supplementary affidavit, then he should serve a copy of the supplementary affidavit along with the petition, so that I may file my stand on both. And a longer time may be given so that by that time the counter affidavit also comes from my side.
No, we want him to
appear before the adjudicating authority. That way, why that is.
So we keep it on 6th of April. That's a virtual day. You get a longer time. Supplementary affidavit you file by 21st of March. Meanwhile, petitioner shall appear before the adjudicating officer and 6th April.
पाँच छः में सोमवार मंगल क्या
6th को रखना।
तो रियल कोर्ट वर्चुअल तो बुधवार है
So, understood. You file a supplementary affidavit containing the notification by 21st of March and serve copy by tomorrow upon him of the writ petition. Respondents shall seek instruction in the meantime and file counter affidavit before the next date. Matter will be listed on 6th April. Tell your client to appear before and file his reply.
Yesterday I tried to find out, but I could not.
Very well. You can supply those judgments a few days beforehand. Yes. Now, your Prabhat Kumar had come.
Yes, but he told me, in fact, I just saw the order also. It would be appropriate for the adoption the granted stay of the Garney degree. Now the matter is tribunal is functioning, so that stay may be extended for a period of 4 weeks. In the meantime, either by stay may be decided or the appeal itself be decided.
Mr. Salona was saying that the next date is 15th of
14.
14th.
But I think they are probably engaging me, he just told me, so I will also have to take some time.
So we can extend this stay till 25th March so that on that day you can seek an extension
2
or.
or 3 weeks, let it be 3 weeks.
Item 21.
In the meantime, the tribunal is deciding the matter expeditiously.
actually. Some is, oh, issue. When I relate that, still is
Otherwise, one of the tribunal is, I think,
4 weeks.
80%, 70% of the matters have been decided. Very,
Very quick and.
very quick and very upfront, and we are enjoying even appearing. The appreciation is also there.
Now about 100 matters are only pending. More than 200 matters have been disposed.
Sometimes happens that when the honorable judges get assistance, it was a time for me that I used to request it. Of course, I got that leave because our high court was not functioning. So every day my matters used to go because my judicial submissions are there, judgments are there. So now, as far as my office is concerned, I think 100 matters of my office is like in 2-3 months. I said, no, I don't have matters before tribunal. He said, no, don't worry, Mr. Lode, you'll have some more. Don't worry, it will come automatically. He is deciding it actually really fast. So only 3 weeks will be given, and basically 31st March if your office protects us, and that is all. And we.
Where is Mr. Salona? Ask him to come. Do you have the copy of that? He had passed on to you the copy of tribunal's order?
Yeah, tribunal the list. Yes.
List, oh.
You have not? Yes.
Heard learned counsel for the petitioners. Learned counsel for the parties. The order dated 8th April 2021, which encapsulates the challenge made in the writ petition and the interim order passed staying the operation and implementation of the Garnissy notice dated 6th November 2020 within bracket annexure 5 is reproduced here under for better appreciation, for easy reference. Stop. Then counsel for the petitioner submits that the commercial taxes tribunal is functional and the, what is the revision number? Suo moto revision case number CCS with CC इसमें लिखा हुआ है उसके ऑर्डर में.
That was dismissed. Mudra construction is revision case number SZ72 of 2020 and SZ73.
Okay.
We said that.
Acha, yes. So give, if it is there in the list, the revision petition preferred by the petitioner before the Commercial Taxes Tribunal is pending consideration, pending adjudication. Stop. The next date is 14th of March 2022. Stop. Land Council for the petitioner submits that the interim order staying operation of the garnishee notice may be extended for few weeks, so that 3 weeks, so that petitioner can seek extension thereof till the revision is finally adjudicated. Stop. Land Council for the respondent state also submits that since the revision petition is being considered is being taken up by the Commercial Taxes Tribunal, the writ petition can be disposed of. In fact, Mr. Mittal was saying that the interim order can be made absolute till the pendency of the revision petition. But we wanted to hear that from him.
That is fair on his part, but not required for 3 weeks. 3 weeks or 4 weeks are required.
So that the क्या लिखे?
Since revision petition
is pending adjudication before the learned tribunal, comma, the writ petition may be disposed of. Stop. We have considered the submission of learned counsel for the parties in the background facts and the interim order dated 8 April 2021 passed earlier. Stop. Interim order was passed primarily for the reason that the Commercial Taxes Tribunal was not functional. Was initiated against the petitioner. Pending. That revision was already pending when the writ petition was taken up.
Yes, it was pending.
Pending and the revision petition preferred by the petitioner was pending before the tribunal. Stop. However, since the Commercial Taxes Tribunal is functional and the case of the petitioner is being taken up for adjudication, we are of the opinion that there is no purpose in keeping the writ petition pending. Stop. The writ petition is accordingly disposed of. Interim order dated 8th April 2021 shall remain operational for a period of 3 weeks from today. Stop. It would be open for the petitioner to.
Actually, it is saying 4 weeks.
No. 14th is in next date, 3 weeks is enough. And the tribunal
14th is the next date.
As by information, LCR was called for, that has not been received.
So, on 14th, you can ask for a date for hearing on the
They will
continuance.
extend it. They themselves will extend it.
So, petitioner is at liberty to seek extension of the interim order before the learned tribunal, which may be considered on its own merits. I mean, 19. पहले कर लिया।
19 crore of course to supplementary वाला 93 वाला है
हाँ,
नहीं sorry हाँ तो 93
राघव पहले सुन लिया कि इसमें अलग अलग
नहीं इसमें क्या
So we'll take up Mr. Mittal's matter because he has concluded half of his submissions, and we are to hear Mr. Pati today, and then your matter.
Item 27, WPT number 4506 of 2021, Mr. Salona Mittal for the petitioners, Mr. P.S. Pati. For the petitioner.
Just a minute.
My entire submission including the judges. The remaining portions of the three judges are also.
Yes.
First, please one paragraph of assessment order. Because that has been dealt and evaluated by the department and divisional. Then I take 2-3 provisions and I will take my. Page 36 of the assessment order. Page 36 of the rate petition. Relevant part of the assessment order. Course. Input tax credit कराओ. आलोचित कंपनी द्वारा राजस्व निबंधित व्यवसायियों से आलू की अवधि में क्रय किए गए मूल्य 6,12,45,780 पैसे पर 5% की दर से चुकाई गई वैट की राशि रुपए 30,62,285 पैसे दर्शाकर इनपुट टैक्स क्रेडिट का दावा किया गया। दावा के संबंध में 61 अदर पेमेंट मूल्यों को कुल 6,04,50,246 पैसे का दाखिल किया गया है। प्रबंध पेमेंट 404 के लिए वैट की राशि 29,33,36 पैसे दर्शाई गई है। परंतु यहाँ उल्लेखनीय होगा कि व्यवसायी द्वारा राजस्व क्रय किए गए माल को अंतरराज्यीय स्टॉक ट्रांसफर वाले 82,887,19 पैसे का किया गया है। अतः प्रस्तुत दावा प्रावधान के आलोक में पोर्शन पार्टी इनपुट टैक्स क्रेडिट दावा अनुमान है। जांच के क्रम में इनका दावा 30,60,62,19 पैसे की है। आवश्यक सत्यापन पश्चात रुपये 14,60,627 पैसे एलिजिबल इनपुट टैक्स दावा सबमिट किया है। But the case of the petitioner is being claimed by falls under section 18, subsection 4, clause 2 of the Act.
Section 18.
Subsection 4. So that is just the reading of the petition and explain that my case falls under this Act. 18(4) input, that's page 23.
Yes.
input tax rate shall be allowed on purchase of goods made within the state of Jharkhand from registered in holding a valid certificate of registration and which are intended for purpose of this case falls under surplus 2. State in course of interstate trade of commerce falling under subsection 1 of section 8 of the Central Sales Tax Act 1956. Because he has stated the declaration in course of interstate trade, I sell the entire stock of the battery which I purchased locally. Rule 26, the actual 18 line I am not placing because that is in table for adoption 18 clause 9. Rule 26, there are this method of given to. Stated is rule 26 or rule 5. That will be at page 343.
Yes.
Where so I am placing this rule because in the contract we have taken a stand that it would not be asserted whether the goods are passed on, transferred in the same form or not. That is when I am placing this. Rule 5.1. Where any bad dealer buys and sells the goods in the same form, the input tax rate can be claimed fully.
26.5.
26 plus page 45 of the rules matter.
Acha rules, check.
Page 343.
Okay. Yes.
Where any bad dealer buys and sells the goods in the same form, the input tax rate can be claimed fully in respect of all the taxable goods purchased for every tax period, excluding the tax paid on purchase of any goods mentioned in subsection 8 of section 18. Such bad dealer is required to make a declaration in Annexure A Form JVAT 200 for every tax period along with tax return. But thereafter, the formula is given regarding the computation of ITC and apportionment in other cases, not in the case of the as claimed by the petitioner. Subclause 12 thereafter mandate regarding maintenance of records, separate 4 separate records.
Where?
Page 347.
12.
Yes. These are the records which have been mentioned in case the ITC is not claimed under the above formula of the rules. But in this case, the assessment order shows that he passed the order taking into consideration the goods stock transfer. Now, the case of the petition is that the stock transfer was of different goods that are the new batteries and the ITC and claiming is of the old batteries. Now, for the first time, what happened from the review order and assessment order transpired that during assessment proceeding he filed a consolidated statement. Now, the first time before the revisional authority, he filed the different statements and ledgers showing the distinct transactions. So that the tribunal said that I will not take into consideration at this stage and did not decide this case whether the case actually falls under section 18 for subclause 2 or not. It simply went on to decide that I will reject those matters because you have not brought it on an earlier occasion, these were not before the assessing officer, and 18.8 clause 9 was taken into consideration. But so far the language 18.8.9 is concerned that crypto censor does not fit in the present case matter. I make my summation on that because reading of that makes it evident that the goods are consumed for manufacture or processing and thereafter either it is stock transfer or a sale is occasioned, the situs of which is not in hand. Either I stock transfer, so it has just to be conditional to fulfill that it is involved consumed in the manufacturing process or processing is done on those goods. So that material is not evidently there in the entire. Yes, but at the same time, this situation arose because of the reason only that the petitioner did not bring forward all the relevant documents before the assessing officer, which he sought to bring first time before the revisional authority. Then in case your Russian should leave this, he may be sent back to the assessing officer with an opportunity to produce those documents. He will examine the correctness of those documents. Because other taxpayer also, he himself admits that yes, his case was remanded back. Based on
The only question is that since he was not a manufacturer within the state of Jharkhand. the petitioner is not a manufacturer within the state of Jharkhand.
Yes.
That is the admitted position.
Yes,
Almost.
they are not controverted. And yes,
Not controverted and the
assessing officer has not brought forward any material to
Exactly.
that effect.
and so the moment he is not a manufacturer in West Bengal, no issue. But so he can transfer, stock transfer can be done.
In the same form or same in the same form. So those things have to be examined. That is my submission.
So
that was never examined
you
by
will-
the assessing officer. He went on a
That
different
is to
tangent,
be
not
proved by you, no?
It cannot be demanded to improve the case and to fill the lacuna.
That
I
is
want to improve my case. The documents that he submitted first and before the
Those documents are not required at all. It is they mother who have to show from the improved proceedings that
From document what you can see.
No, whether
Because from the
in
right-
form those goods were transferred or
Prima
not.
facie it appears right from the assessment order itself. You were considering the petitioner as manufacturer.
And one more thing, whether he considered that these goods were, he went into considering the stock transfer goods. Now, whether the stock transfer was of the same good against which ICC was claimed, that was also not seen by him. Now, because he deals in both kind of batteries, I understand whether because the reason he deals in both new and old batteries and the manner of transaction, so far new battery is different and old battery is different, this created the entire confusion before the assessing officer.
No. For the purchase of the scrap batteries, for which he is claiming ITC
Yes.
for a particular amount,
Yes.
what document was he required to show?
Whether his trading accounts, he has only given the JVAT forms.
JVAT 404.
Yes,
JVAT 404 has he given or not?
that he has given.
Why does the assessing officer does not believe that?
But because
To the extent-
also is required to maintain separate accounts of all the goods which are taxable, which is stock transfer, all those here, and he has in fact given those statements before the tribunal authority. Before the tribunal, he himself volunteered to file those documents, saying that these documents are relevant for my case.
No, in that case, why has the assessing officer accepted part of it?
But the reason I understand whether the entire confusion went because he filed a consolidated state return.
So
statement.
then
He did
in
not
that
file
case,
state
he applied the principle of apportionment.
For 18-9, because all the facts perhaps were not before him, the state, the account.
Any registration number is there.
But on facts, whatever both of you have understood should be made clear to us as to why the entire ITC was not allowed.
But he only took, I
Manoj, may I assist on this? Manoj, everything was there to the assessing officer. Manoj can have the assessment also. At page 1 of the assessment order, that is page 35 of the expedition, Manoj, the trading account is also there. We claim 100% ITC since we were not manufacturer. Now, Manoj, what the assessing officer does, he presumes us to be a manufacturer and he applies 88(9) to us and apportions the ITC. So the limited question is when.
So
this
for apportionment under 1889, what more documents is required for this? No. What more document is required for the assessing officer to do that?
He has to show that I am a manufacturer. That's it. 1889 would come because Madam, we had already admitted that it's an interest rate transaction. The only thing which was left was that we should have been a manufacturer. The moment we would have been a manufacturer, 1889 would have come into place. There was nothing else to be done on any of the sides.
one thing remains.
So, Madam, this fact was never alleged either by the assessing officer nor by the appellate authority. So, in the absence of this jurisdictional fact, Madam, that I am not a manufacturer, how 1889 can be applied to one case? That is the limited question.
Thereafter, madam, once it is held that 1899 will not apply, thereafter he has to pass the order afresh because he has passed the order on wrong basis. He has altogether taken into consideration irrelevant facts. So he needs to apply his mind and pass an order.
Second.
Goods in the same form, the rules as per the rule for getting the 100% refund, benefit of ITC, he has to also show that the goods were transferred in the same form.
It is like my learned friend is arguing like the income tax matter, the assessing officer adds certain income. Those incomes are later on held by law that illegal and then matter will be demanded to the assessing officer for a reassessment. But this
cannot be done, brother. It cannot
All
be
the
done.
papers were before you. You never disputed that he is not a manufacturer. Rather, an analogy has.
Worse situation than I was.
An analogy has been framed in the mind of the revenue that he might have manufactured some item in a state of Bihar, this state, and thereafter sold it.
No.
But for that you have to prove now how the SSC will give that I am not a manufacturer except the registration number. That is the,
89 to, I also submit.
and that is the only issue.
Sustain.
That is the only issue.
Thereafter, there has to be an independent application of mine by the SSC. But this ITC claim is concerned, limited to this. Other claims have been accepted. Nasil also part of this claim has been accepted.
ITC, so far as purchase of scrap batteries sold within the state and supported by JVAT 404. This is the basis principally on which ITC is allowed by the SSC.
And as per the rules also, when he claims the full, yes, that is the correct. So this is fine will also be there. That is, that those were transferred in the same form. That is also a requirement for getting the full refund.
So that evidence, where from it will come?
But when he documents that he produced before the revisional authority, when he produce all those documents, he himself sought to induce those documents.
What documents did he
Or
produce?
the books and the accounts which shows that the different category of goods which were liable to tax, which were stock transfer, all those documents he has given before the revisional authority. That this was the category of good that I had stock transfer. This is the goods which was liable for tax. This for rate of tax. This was the local sale. This was the interstate sale. All these he has filed. And that was
My learned friend was never agreed by the assessment order. If the department was agreed, no more revision could have been done by the commissioner. Now my learned friend is trying to remand the matter just to fulfill the lacunas of the department. If the assessment order was bad, they should have challenged it. Or they should have brought it to the notice of the commissioner in form of revision. All
No,
the way they supporting the assessment order.
Perhaps he is carrying an impression that since 1889 won't be applicable, then for claiming full ITC for the purchases of scrap batteries and sold within the state, apart from JVAT 404, other documents which you have produced during the revision, these need to be looked into by the assessing officer to give a clear finding.
18.8, what has been applied to my statement? 18.8 Roman 9 has been applied for disallowing the ITC. The only question is whether that is applicable to my case or not. If the department would have applied any other provision of law, then it would have been a different situation. The assessing officer applied 18.8.
No, suppose the matter is remanded to the assessing officer to
What is the harm?
to undertake a fresh exercise, ignoring 1889 from his mind, and look into these documents very well. How does your interest suffer?
I can't be in a position worse than what I was before the other lower authorities.
No. How could you be worse?
Because I will be subject to a reassessment. But then, this will open floodgates, man. In all the revenue matters, then the revenue will argue, because I also represent revenue on the direct tax side. Then I have to argue that no, this provision is not applicable, this provision has been wrongly applied, I will demand the matter back. So this will open floodgates, man.
Previous years, financial matters were remanded back, as he has accepted in the repetition also.
Remanded by?
Remanded back by the appellate authority to the assessing authority. When it was, he says on similar ground it was rejected, and after those cases were remanded for looking into the documents.
Will be applying the principle laid down by the Honorable Supreme Court in Mundra Singh case, what is there in the ensuing proceedings has to be seen. They cannot add or omit neither of the parties. The only thing they have to show is that I am falling under 1889, that's it. So had there been a reason that my IPC was disallowed for any other ground?
Page 47 of the supplementary before the tribunal. They say this fact, my lord, in so many words. That other period was remanded. This period also they say. This is the supplementary before the tribunal. Further, the apparent company has stated that fresh batteries which are received in stock transfer to other state under section 6 of the CST Act, and scrap batteries which are purchased within the state are sold outside the state, and scrap batteries are not stock transfer. Appellant dealer has filed details of purchase within the state, details of interstate stock transfer outside the state, month-wise stock receipt, detail along with some copies of the invoices. They thought to adduce this evidence before the tribunal only to establish, because they also take are aware of 26.5. Just in the para above that, they state about 26.5. That in the same form it is transferred.
Once I am not a manufacturer,
I am not on 89. In the same. I am not making it a case of 89.
I do not fall under 26.5. It is one of these onus lies on the revenue to show that I am being disallowed for ITC. He cannot shift the blame upon the assessee. Yes, the revenue cannot shift the blame upon the assessee.
I am not saying that the onus will lie on him. I don't say that.
The assessment order it was annually considered is very specific. Why my ITC has been disallowed? My ITC has only been disallowed because he is satisfied with all the other conditions. He says 1889 is applicable to your case, therefore I am apportioning. Not only the assessing officer, even the appellate authority says so.
What is the meaning of this sentence at page 36 in the परंतु यह उल्लेखनीय होगा कि व्यवसायी द्वारा
किए गए माल मतलब इंट्रास्टेट परचेज किए गए माल को अंतर राज्य इंटरस्टेट स्टॉक ट्रांसफर for the purpose of interstate transfer rupees 2.28 crores तक किया गया. What it means is that it has to be taken note that the assessee during the concerned period has had made intrastate purchases and
For
interstate stock transfer to rupees
and
rupees 2.28 crores. अतः प्रस्तुत दावा पूर्णतः अनुमान नहीं होगा. So it is on this limited factual thing he applies 1889.
And it does not take notice of the fact that there is no category of
without even alleging that I am a manufacturer.
There were two categories of batteries.
Oh, there is a provision,
This
sir.
was the new battery, perhaps.
There is a provision in the Act to take action against the assessing officer by suo motu reason.
My challenge, all the challenges are by me. They are trying to fulfill their landmarks in my challenges.
sanction पे हुआ
30,62,285 you are claiming as ITC. To that extent, your JVAT 404 also shows.
My JVAT 404 is 40 short of some figure.
29 lakhs.
But in appeal that was allowed.
In appeal there was that produced. Now JVAT 404 is complete.
1,82,000 was allowed in appellate court said, he was doing appellate court said that if those documents are well, you look into it. That order is
JVAT 404 is now complete. So that is not understand, that dispute is not there. That is there.
So if 26.5 formula goes, then you get the benefit of full ITC against that.
18,890.
Sorry, 18.
1889 is the only obstacle which I have to clear. So that is why I have been disallowed.
Thereafter,
The income tax says, if I will be further, I'll give an example. If an assessee claims an expense, and that expense is disallowed by the assessing officer, then it is added to my income. Simply, in the subsequent proceedings, if I can demonstrate to the tribunal or the High Court in appeal that this is an expense to be allowed, so then this expense is allowed and it is deleted from the income. Simple, he has done the same thing. He has disallowed something which I was claiming.
वही फंडिंग ही है टोटल ओनली फंडिंग किस तरह
Against. Land Council for this state, Mr. P.S. Pati GA2 has advanced his arguments. Stop. Petitioner has also made his reply. Land Council for the petitioner has also made his reply. Orders reserved. The case under heading for orders on 22nd March 2020.
My senior grade.
He appeared, give your appearance. Yes.
Item
Let Mr. Garodia's case, because your case has been passed over too many times.
I'm sorry, but in fact, I was also speaking with the I could not attend the morning.
Anyway, so after Mr. Garodia finishes this,
Otherwise, it will be another 2 minutes, whether the matter does not consist of anything, so far as the issue is not clear. Only thing that was to be taken into consideration whether the instruction issued by the examiner can be said to be mandatory or it was valid. If it was mandatory, then only matter can be considered, otherwise does not have to be. And the nature of direction which has been given cannot be said to be mandatory unless there is a rule or act which has been provided. Unless that is, therefore, will not ever exist.
I am also in some difficulty in second half.
No, well, your logic may pass valid order valid even my absence also means so far as that issue is concerned.
so both of your matters will be finished off in the first half itself. This matter will take 5 minutes maximum or 7 minutes.
No, I don't have any problem in even the second half.
Because he has already given an indication as to what is the outcome of his appeal.
I would only request, but I am actually in two parts.
Nothing to be insisted upon or to be persuaded.
So now from here your colleague would take over.
So we can then finish off his matter, a very short matter, so that we give you exclusive hearing.
Yes, therefore I asked him, yes, I will take only 2 minutes more.
And your two points we have heard on the previous date.
Yes,
One, not yours, Mr. Garodia's. One relying upon NKS and the other point relating to some facts. Personally.
Personally.
Item 16, LP number 412 of 2020.
The fact that the advertisement of 5th January 2016 and appointment letter issued on 15th February 2016 by the Madrasa are not in dispute.
No, that is not.
The fact that they send it with a delay in July 2016 is basically the main reason why the Jack is saying that you have taken more than 45 days to conclude.
In fact, when the matter came up before the JAC for the purpose of confirmation of the appointment made by the committee itself, then the JAC has refused that because the direction which has been issued to the authority, to the establishment committee for the purpose of appointment, there was a specific direction that it is to be completed within 45 days.
Without any rider that if not completed.
Yes, there is no rider or the consequence has not been mentioned therein. Therefore, the JAC when it has come for confirmation, it was rejected.
And the learned single judge has opined in favor of the petition.
Yes, sir, that.
Third learned senior counsel for the petitioner, third learned counsel for the parties. Stop. Jharkhand, aggrieved by the judgment dated 13th October 2020, passed in WPS number 6630 of 2017, The appellant Jharkhand Academic Council is in appeal. The respondent number 2, Jharkhand Academic Council is in appeal. Stop. Writ petitioner, respondent number 5, was appointed on 15 February 2016. As the undisputed facts unfold, writ petitioner was appointed as an assistant teacher in the Madrasa Ezazul Ulum Sursura Nawadi, pursuant to a recruitment exercise including examination held under advertisement dated 1st January 2016 and 5th January 2016. Stop. From the date of the advertisement till his appointment, 45 days were approximately consumed. Stop. However, the recommendation to approve his appointment was sent by the, what is this, governing body or management committee of Madrasa on 28th July 2016. As per the minutes at annexure 9 of the same date. Stop. Jharkhand Academic, the appellant, Jack, refused approval as the recruitment process was not completed within 45 days in terms of their letter dated 4th September 2015, bearing number 3730/15 annexure 1, whereby the writ petitioner, whereby the respondent number 3, Secretary Madrasa Ezazul, Secretary of the Madrasa, was granted permission to undertake the recruitment exercise stop. Clause 3 in particular, as per the appellant Jack, clause 3 in particular was not strictly followed. Stop. Which prescribed 45 days period for completing the recruitment process was not followed. Clause 3 reads as under. Stop. Learned writ court, upon considered the undisputed facts of the case of the parties and found that the delay in seeking approval by the Madrasa, approval of Jack by the Madrasa, was not fatal to the appointment process, holding as under para 12. Stop. Learned Senior Counsel for the appellant submits that the recruitment process, the delay in recruitment process and seeking approval of Jack is the reason for rejection of confirmation of the appointment of the writ petitioner. Stop. Learned Senior Counsel for the appellant, however, is not in a position to dispute that clause 3 of letter dated 4th September 2015 did not specify any consequences for non-adherence thereto, adherence to the time limit, nor is there any statutory backing to the said condition. Stop. It is also not disputed that writ petitioner, the appointee, was at any time responsible for the delay. Stop. Appellant Jack has not shown that the recruitment process suffered from any illegality or irregularity affecting the appointment process and being in teeth of Article 14 and 16 of the Constitution of India. Stop. The appointment was undertaken after an examination and pursuant to an advertisement to the public at large, in which writ petitioner and other eligible candidates participated. Stop. Having learned you are for writ petitioner. Okay. When counsel for the state is present and submits that the state doesn't have much role to play in the matter. Stop. We have considered the submission of learned counsel for the parties. We have perused the impugned judgment and gone through the materials placed from the record. Stop. The sole ground for refusing confirmation of the appointment of the writ petitioner, is non-completion of the appointment process within 45 days as contemplated under clause 3 of the letter dated 4th September 2015, Annexure 1, issued by the Secretary Jack to the Secretary of the Madrasa. Stop. The said condition does not have any statutory backing and does not stipulate the consequences arising for non-adherence thereof. Stop. As such, the said condition cannot be stated to be a mandatory condition which may lead to annulment of the appointment process. Stop. Writ petitioner has not been responsible for the delay in sending the recommendation to Jack by the Madrasa. Stop. No irregularity or illegality in the appointment process has been alleged or proved. Stop. The appointment process has been done in consonance with the principles of enshrined under Article 14 and 16 of the Constitution of India after due advertisement and examination process. Stop. Learned single judge has taken a correct view of the matter and rightly issued direction upon the JAC to award to grant approval in favor of the appointment of the petitioner. Stop. We do not find any error in the impugned judgment. The appeal is accordingly dismissed.
Item 90, WPT number 3908 of 2020 along with item number 20.
First, it got covered by a lordship judgment that no so-called notice was issued ever to the applicant. That's how you know the expectation. The lordship may come under the Article 01 which has been issued. Say that page 193.
Of the compilation, writ petition.
Before that, I just show page 191 because that's same in the pattern of NKS. They issued the DRC 01A saying that you discharge the liability paying with the so-called notice of issued. Page 19, page 191.
Yes.
So they say will refer to the above proceedings with regard the amount tax interest penalty payable by you under so and so with reference to the that they has ascertained by the undersigned in terms of the available information in that below. You are hereby advised to pay the amount of tax as ascertained above along with amount of applicable interest and penalty under section 74(5) by 19(2), failing which so-called notice will be issued under section 74(1). And then the so-called notice is the RC01. It's not the so-called notice, but summary of the so-called notice at page 190.
Page 193.
Annexure 20.
Yes.
This is all which has been issued to the form DRC, GST DRC01. May I just read that one?
Yes.
पश्चिम अंचल के पदाधिकारियों द्वारा प्रतिष्ठान का निरीक्षण 28/19 को किया गया। तत्पश्चात व्यवसायी के समस्त लेखा पुस्तकों की समेत जांच अपने कार्यालय में अधिकारी के द्वारा की गई। ये पाया गया कि व्यवसायी द्वारा निर्गत किए गए टैक्स इनवॉइस मूवमेंट ऑफ गुड्स के लिए प्रस्तुत किए गए साक्ष्यों से मेल नहीं खाते। किसी भी क्रय विक्रय से संबंधित माल के समर्थन में मूवमेंट और गुड्स के साक्ष्य प्रस्तुत नहीं किया गया। इससे यह स्थापित हो जाता है कि इनके द्वारा किए गए समस्त व्यवहार कागजी समझदार एवं फ्रॉडुलेंट तरीके से आईटीसी का उपयोग किया गया है। व्यवसायी का ये सिर्फ झारखंड माल एवं सेवा कर अधिनियम 2017 की धारा 16 के प्रावधानों का सख्त उल्लंघन है। इस कारण से जानबूझकर रॉन्ग अवेलेबल ऑफ आईटीसी कर लिए जाने के कारण पूर्व में आपको डीआरसी 01 के माध्यम से धारा 74(5) के अंतर्गत कर ब्याज एवं शास्ति के भुगतान दिनांक 19/2 तक करने हेतु सूचना निर्गत की गई थी, जिसका अनुपालन आपके द्वारा आदि दिनांक नहीं किया गया। झारखंड माल एवं सेवा कर अधिनियम की धारा 74(1) तथा धारा 50 के अंतर्गत कार्रवाई प्रारंभ करने का निर्णय लिया जाता है एवं शास्ति तथा ब्याज की संगणना निम्नवत की जाती है। This is all about now there is something more clear which I just want to show you your option. But in this DRC01 there is no date fixed. When I have to file my reply it is not fixed. But kindly see the date at of the 14th March 2020. But by way of abundant caution, since they have not said anything to me on the RP01, but I at page 195 on 17th March 2020 itself, within, in fact, on the day when it was received, but I'll take it that it was received on 14th March. On page 195 itself, we request you to grant 4 weeks time to file reply to the so-called notice issued by a hotel. And Your Lordship, this is 17th March, Your Lordship, lockdown took place from 22nd to 23rd March 2020. And Your Lord, kindly see the order sheet now. And I do something more grave here, Your Lord, but first the order sheet at page 214. And Your Lordship wanted this order sheet to be filed by them also specifically, because there is something more which is grave here, page 214. The correct copy is also there, so otherwise I will have to go to page 214. But I am reading the 14th March order, by which it was recorded that DRC-01 is being issued. अभिलेख के अवलोकन से ये ज्ञात होता है कि मामले में DRC-1 ने इतना दिनांक 29 को व्यवसायी के मेल पते पर दिनांक 5 को प्रेषित है। दिनांक 29 तक व्यवसायी को इस मामले में रिस्पॉन्ड करना था, जो आदि दिनांक प्राप्त है। वन्य स्थिति में अग्रतर कार्रवाई करते हुए DRC-01 निर्गत करने का निर्णय लिया जाता है। 17-18 से 18-19 के लिए अलग DRC-01 निर्गत करें। Both the matters are before your Lordship. Now, on 14th March, then they say it is mailed to me. Now, kindly come at the bottom. Next is the next date. The next date is 14th August 2020. The original certified copy. व्यवसायी के ईमेल पते पर DRC-1, DRC-2 रेफरेंस नंबर so and so प्रेषित है। व्यवसायी की ओर से भुगतान संबंधित कार्रवाई शून्य। कोविड-19 के कारण एक से अधिक अवधि व्यवगत हो चुकी है। फलतः मामले में DRC-7 निर्गत है। On the face of it, 14th March, and this is the next date on 14th August. Just to show something more grey, your Lordship may kindly come to the DRC-07 which was issued to me. It has page 197 and extra 23. Have you got it?
197.
Yes. Now, this is DRC-07. Kindly see the date, 11th September 2020, and kindly see the details of order. Order number 210, dated 11/9/2020. Your Lordship, I have applied for the certified copy of the entire order sheet. The last order is 14th August 2020, which I just showed to your Lordship at page 214.
Yes.
And in the DRC-07, they say the date of order is 11th September 2020. Now, my Lord, your Lordship directed them to produce the entire order sheet as per their records. They have filed by way of supplementary affidavit. It's just identical to what I have produced. Now, my Lord, see the mischief here, how they do the entire proceedings. The date when I had challenged, but I said that I have not even got the adjudication order because they have not passed any adjudication order. So, your Lordship is seeing the supplementary affidavit, my Lord, if your Lordship will see for a moment. The supplementary counter affidavit filed by the respondent states, pursuant to your Lordship's direction. In that, the entire order sheet is annexed, and at page 21 is the same last page of the order sheet.
Supplementary.
They have filed two supplementary orders. The first supplementary, they have filed two supplementary counter affidavits. The second one, dated
26th June.
no, it says 8th March 2021.
9th March.
9. In that order, it starts, the same order sheet starts from page 16. Page 21 is the
Yes.
order sheet which I have read to your lordship, then the order sheet get over. So there is no order, there is no proceedings on 11th September. Now, my lord, they did as much as specific pleading in the writ that there is no adjudication order passed. So in the counter, they annex an adjudication order, which is on the face of it anti-dating. But even kindly see when they make anti-dating, the date of the adjudication order is 13th August. चोरी करने में भी बेमानी है, चोरी करने में भी ठीक से चोरी नहीं होगी. The date of the anti-dating order is 13th August 2020. The next page, the page if you wrote to that page 21. After that, there is an adjudication order which they purportedly passed. Nothing on that also. It is 13th August 2020.
And in the original order sheet, the next date is 14/8.
Yes, 14/8. 14/8 में पहला बार proceeding कर रहे हैं मुझे after COVID.
And this order of 14/8 doesn't say that on 13th order was passed.
Yes, it doesn't say that 13th order was passed. Even 13th an order is to be drawn, then he has to write in the order sheet that I did not appear. There is no so-called reply. And my lord, what is the transaction, my lord? I will just try to explain to your lordship how they act, my lord. I am one of the largest trader of coal in the country. My lord, I have just shown my turnovers. If your lordship may just take, my lord, page 12 of my writ application. It's just pure and simple harassment. Page 12.
Earlier we have passed some interim orders.
So your lordship said when it was taken up first, your lordship said immediately to file counter affidavit. There was no interim order as such. I had in fact insisted that it can be disposed of on the first day. Initially, your lordship were of the opinion that CGST is also a party, my lord.
That's section 6.
Section 6, then CGST came that we have no role to play. So, my lord, I'll just explain who I am, my lord.
Now, what do they say? They say about all this.
My lord, in fact, what they say now is also even more funny. Kindly see their counter affidavit, paragraph, but complete lack of understanding to what can be a entire proceedings. Paragraph 22 of the counter affidavit, kindly read that. In paragraph 22 they say we have already passed an adjudication order at the inquiry stage on 28 January 2020 and the show cause notice was issued pursuant to the adjudication order passed.
Yes, what defensible or indefensible?
Well, this is quite defensible, but I have taken instruction on this point, what my learned friend was arguing. Lord, kindly see the supplementary counter affidavit which was referred to by my learned friend. This order is, the order cannot be in error. The procedure has to be followed and the procedure has been followed. My lord, my learned friend was referring to order dated 14/8/2021. Now this order, my lord, if I may be permitted to place 1 second, my lord. व्यवसायी के ईमेल पते पर सो एंड सो DRC 1 एंड DRC 2 सो एंड सो रेफरेंस ऑफ प्लेसिंग व्यवसायी की ओर से भुगतान संबंधी कार्रवाई सुनी कोविड-19 के कारण 1 माह के अवधि की ये हो चुकी है अतः मामले में DRC 07 डेट मतलब the order was passed on 13th. A separate order sheet was drawn that is at page 22 of the supplementary counter affidavit. And in absence of the separate order sheet, my lord, passing order under section 74(9), my lord, no summary order number DRC 07 could have been ordered issued, my lord, because DRC 07 is uploaded on the website on the portal, my lord, only after passing of the order, because the website it will not accept without the order sheet.
When was DRC 07 uploaded?
My lord, it was uploaded because
when?
I have
when?
It was uploaded on 11/9. after passing of this order, my lord, and 48, my lord, there was COVID-19 lockdown, my lord, something happened. Therefore, it was uploaded later on 11th. Only mistake what the department has committed, that in the summary order, instead of recording the order of 13A, it has been recorded as 11/11 because it has been uploaded on 11. That is the only mistake that I can admit, no, as per the instruction given to me.
And in the order sheet in which orders of any proceedings are drawn, the date on which an adjudication order is passed,
Yes, sir.
that date does not have any place in that order sheet.
My lord, in that order sheet, it does not find place, my lord, because it was passed separately on 13, my lord. That we have included, my lord. That is there.
That is what we are asking.
Yes.
How it is
That
possible?
My lord, it is possible because the detail.
What is the practice?
regularity of any official proceeding is done. Suppose we are passing an order in this repetition.
What happens, my
So,
lord?
listen, now you have made that point. We are intelligent enough to appreciate
Yes,
that.
of course.
This is a writ proceeding. We fix a date of 29th of March. Before that date, we pass an order. Any order in this writ proceeding, we pass an order. 29th March, when it comes, we don't make a mention of any order passed in between these 20 days. And then on 19th of April, we issue a decree kind of a thing, executable order, DRC 07. And then we say that no, before 29th of March, we had passed that order. The whole concept of regularity of any official proceeding is because it has to be maintained in a format. Not that it is at the whims of a officer, a judge, to delegate from that and keep an order somewhere else. In that order, not even mention that the party participated or not, or whether any hearing was held or not, reply was considered or not. वही तो इनको समझा रहे हैं. इसीलिए मिस्टर यादव, if it is not a defensible order, then better not engage us in this unnecessary exercise, because then our ire will grow. We already are quite annoyed with the kind of manner in which the officer has conducted the proceeding. And we are not here to waste judicial time with these kind of proceedings. In fact, they call for some kind of a action on the administrative side or on our judicial side if we may be compelled to pronounce something.
But I would request, something should come from your lordship now. But if we have been facing this, this is not the first matter. At least I have 24 matters before your lordship will come like this. And Lord, can we see one thing, one judgment, one provision, Lord? Section 75(4). Lord, with all due respect, Lord, the state authorities just don't know what is the act. Section 75(4), Lord, if your lordship may see, it specifically says, when you contemplate passing an adverse order, then you have to give an opportunity of hearing. Lord, at least 6, 7 High Courts have interpreted it by saying that it has to be an opportunity of personal hearing. My Lord, kindly see my predicament. My Lord, I have been issued a notice on 14th March. I go myself. But in fact, they consulted me. I said that एक application कुछ भी डाल दीजिए. कि भाई, we are appearing and we are doing something like that because no date is given. So they appeared on that on said that give us 4 weeks time. So but this and but what is the show cause notice? But they don't even spell out one single document, relied upon document against me. But the entire procedure, but if your lordship in this matter, if your lordship so deems appropriate, but the circular, master circular, which was even considered in NKS, if your lordship will take that master circular for a moment, with page 70 of my compilation. Page 17, Lord.
17.
Yes, 17. It's a master circular on show cause notice, adjudication and recovery at the erstwhile regime. Now, let us kindly come to page 19, show cause notice 2.1. Show cause notice is the starting point of any legal proceedings against the party. It lays down the entire framework for the proceedings that are intended to be undertaken, and therefore it should be drafted with the utmost care. Issuance of SCN in a statutory requirement, and it is the basic document for settlement of any dispute relating to tax liability or any punitive action to be undertaken for contravention of the provisions of central excise and the goods trade thereunder. SCN offers the notice an opportunity to submit his oral or written submission before the adjudicating authority on the charges alleged in the SCN. The issuance of show cause notice is a mandatory requirement according to the principles of natural justice, which are commonly known as Audi order of Carter, which means that no one should be condemned unheard. Then structure of the show cause notice. Your Lordship had asked us, these are the structure: introduction of the case, legal framework, factual statements and application of evidence, discussion facts and legal framework, discussion on limitation. Then, my lord, the adjudication proceedings are detailed from page number 10 onwards, and relevant is, my lord, page 13. Paragraph 10, my lord. Paragraph 10, page 27, adjudication of show cause notice. Then it is the officer limit which is given. Paragraph page 31, if your lordship may see. A show cause notice and document relied upon in the show cause notice needs to be served on the SSE for initiation of the adjudication proceedings.
You are referring at which page?
Page 31. Because ultimately, this is for the benefit of the revenue. I say, if I am a person who is actually a defaulter. So, page 31, a show cause notice and the documents relied upon in the show cause notice needs to be served on the SSE for initiation of the adjudication proceeding. The documents records which are not relied upon in the show cause notice are required to be returned under proper receipt to the person from whom they are seen. Show cause notice itself may incorporate a clause that unrelied upon records will be collected by the concerned person within 30 days of the receipt of the show cause notice. The designation and address of the officer responsible for returning the relied upon documents should also be mentioned. Then there are filing of written submission and then personal hearing, 14.3. This personal hearing was even not there in the earlier statute, Here it has been specifically brought in the present statute. After having given a fair opportunity to notice for replying to the show cause notice, the adjudicating authority will proceed to fix the date and time for personal hearing in the case and request the SSE to appear before it for a personal hearing by himself or through an authorized representative. At least 3 opportunities of personal hearing should be given with sufficient interval of time so that the noticee may avail opportunity of being heard. Now, the same thing is here in our statute. If your lordship may see here, given the provisions of the statute, the statute says that at least 3 opportunities may be given. Don't give more than 3 attempts. But that is that page.
Yes, yes, sir.
Yes, your lordship has seen that page 11. So, one or detailed subject to lordship kind consideration. One detailed order by the highest court of this state is required.
What? How many times the same order will have to be passed? We passed NKS, then we passed several more orders. We asked the respondents whether you want to rectify. Mr. Sachin Kumar said that Lordship may pass this time.
From this side.
From next time we will rectify. So every time, how much of? I said you draw the order and give it to us. It's an onerous. I mean, every
I
important
that, but for a relevant. Now, I will kindly see the SSE before your lordship. What is the allegation? I am Indian origin coal. We are the biggest trader, one of the biggest traders in the country, and we supply to only government agencies, MSTC, West Bengal Power Development Corporation. This is our main customers from Calcutta. We are Calcutta based. Now, we purchase coal from Jharkhand from the HEC, Coal India, CCL, BCCL. We purchase from Jharkhand. Now, what at times it happens. There are 2-3 more traders because Jharkhand is one of those primary coal feeder locations. There are 2-3 more traders. Now we have firm orders from our clients. Now sometimes when we participate in auction, we may not succeed in that auction process. My competitor will succeed. So my lord, I have to purchase from that competitor. Same happens to us when we have excess coal, my competitor wants it from me. So all movement of coal is taking place through rail. All purchases are ultimately from CCL, HEC, JSMDC. But interstate transaction between me and my competitor which has taken place, my entire ITC of 182 crores is denied by the judge. And again going back to the officer, I know how difficult it is. The final order and the show cause says one thing. So these are documents. Your lordships may see page 176 just for a moment.
176 of
my writ petition, Lord. When I had produced the documents, they were satisfied with all my inward documents and everything which is recorded there. Except they asked me certain further documents, 2-3 documents. At page 176.
that was at the stage of section 71.
Yes, 71 too. Even at that stage they are recording, but I just want to show that.
You are referring to page 176.
Yes, page 176.
आपके द्वारा बैंक
आपके द्वारा प्रस्तुत कागजातों की प्रारंभिक जांच के क्रम में पाया गया कि आपके द्वारा बैंक अकाउंट का स्टेटमेंट नहीं दिया गया है। पुनः उपलब्ध कराए गए एक्सट्रैक्ट से ये स्पष्ट नहीं हो रहा है कि सर्वश्री एमएसटीसी को जो आउटवर्ड सप्लाई दर्शाई गई है उनसे संबंधित भुगतान किस प्रकार प्राप्त किया गया है। एमएसटीसी द गवर्नमेंट ऑफ इंडिया अंडरटेकिंग फॉर टू चेक। पुनः सर्वश्री, दिस इज वेरी इंपॉर्टेंट, पुनः सर्वश्री आरएसक्यू से प्राप्त आगत माल के लिए निर्गत टैक्स इनवॉइस एवं मूवमेंट ऑफ गुड्स का साक्ष्य दिया गया, परंतु आरएसक्यू को दिए गए आउटवर्ड सप्लाई के संबंधित टैक्स इनवॉइस एवं मूवमेंट ऑफ गुड्स से संबंधित साक्ष्य प्रस्तुत नहीं किया गया।
मतलब at one stage दिया गया है फिर नहीं दिया गया।
जो हम करते थे वो gold dispute started because there was interstate transaction between RSQ from whom I purchased goods and even sold goods to RSQ during the year. Inward wala they are denying me ITC. So inward movement they are saying I have given all the documents of RSQ. The document which I have sold to RSQ you have not given me. So cash RSQ is there.
Agat means inward.
Inward and out here. And now even those are given on the next day. At page 177.
Yes.
All this, with all due respect, I can only say the petitioner was being continuously harassed at the department level, and I don't want to say anything beyond that. And thereafter, the manner in which the proceedings have been drawn speaks volumes. A public limited company is being harassed in this fashion.
Yes, Mr.
The petitioner was given ample opportunity. My lord, they could have obtained that the certified copy of the order from the concerned authorities, my lord, on the day itself, my lord. Your Lordship, just I wanted to point out that on 14/3/2020 itself, the RC1A was issued, my lord, and subsequent thereafter sufficient opportunity was given. At least 5 months. 5 months was given.
You ask your Commissioner Commercial Taxes to review.
Yes, I will ask, my lord.
And these officers also.
My lord, the commissioner will be competent to explain you.
No, the officer who has prepared these
All this order
order
sheet
sheets also.
and original recording.
My lord, this order, my lord, that has been passed by Rajikar I Pashmi Anchal Ranchi. I will call him now. He will explain now. Let it be on Monday or Tuesday, my lord, any day I will not. It will be better, my lord. He will be able to explain more explicitly, my lord. Because he says that he passed the order separately and thereafter it has been recorded. For 5 months, he has not responded, nor payment, nor any show cause.
And where is the show cause notice under section 74(1)? Your DRC 02, DRC 01. No, the statement is DRC 01A.
Yes, that is intimation.
Intimation. That indicates that if you do not deposit, notice under 74(1) will be issued.
एक इनको एक और चीज नहीं पता है, मतलब बेसिक जिसको कहते हैं, ये DRC 1 जो इशू करते हैं हर केस में, उसके साथ में DRC 02 का एक स्टेटमेंट इशू करते हैं. Now you also see the provision what is DRC 02. But DRC 02 is that in a case where already certain proceedings against an SSC for an earlier period has been drawn on the same facts and a show cause has been issued, under those circumstances you can issue a summary statement in the form of DRC 02 by saying that the facts of the earlier show cause notice is the same. हर केस में क्योंकि इनको 1 and 2 का डिफरेंस ही नहीं समझ में आता प्रोविजन पढ़ के, तो हर केस में 1 and साथ में 2 भी इशू करते हैं. But the commissioner present with the one of the officers of the rank of Joint Commissioner or maybe Commissioner of the CGST now. He has been posted very recently, 2-3 months back. So he may now appreciate everything. It is a statement under section 74(3) or 73(3).
That is what I was also going to refer to. So, where is that show cause notice under 74(1)? Mr. Yadav, you the RC01A is at 191. All these have been shown to you. We are saying, you are saying.
DRC 01, my lord.
Have you read our judgment, NKS judgment you have read? So, then what is your answer? Where is that, sir, notice under 74(1)? Your DRC 01A in this second last paragraph says, telling which show cause will be issued under 74(1). Where is that 74(1) notice? है कोई 74 तो you have read our NKS judgment पढ़े हैं ना? Where is that?
That appears to be missing in this level.
Missing
Missing or
there is no notice under S. Have you not, are you not following whatever he was arguing? We listened to you very carefully, both sides. You should also listen to what your counterpart is saying. Where is 74(1) notice?
That is not right.
Then, on that score itself, there is no notice in the eye of law before the adverse order is passed.
ARC 01 is there, Bhagat, and that is not followed.
NKS जब आप पढ़ें, you are a lawyer. किसी कोर्ट में जहाँ आप अपीयर करते हैं, उस कोर्ट के जजमेंट को आप तो कम से कम बोलिएगा ना कि वो नहीं हुआ है हजूर, फिर भी डिफेंड करिएगा. What will be the fate? The problem is that every time this instance is coming and we are compelled to say the same thing, except that the narration of facts we have to repeat. And what liability or what adverse effect it entails upon a particular petitioner, that we don't even go into, because that is not our concern. Somebody 1 crore, somebody 180 crore, that is whatever is the liability or may not be the liability. But the mandate and procedure of law is something which obviously we are concerned. Legislature's mandate has to be, we have to administer law as per the constitution and the laws. Where is that 74(1)? If you have understood, Mr. Yadav, the gravity of the lacuna in the proceedings, in that case, should rectify on your own. If you have understood, what more we will understand from your officer? Your officer briefs you and you are satisfied objectively that there is no 74(1) notice, that there is no reference of the order of 11th September in the main order sheet, and on 13th August itself the order has been passed. All these things are not enough serious. Then what is the sanctity of any adjudicatory process? If the officer will take out one particular sheet of paper from his backpack and say that yes, ये हमने पास करके रखा हुआ था.
There are some procedural irregularities that needs to be rectified.
You are saying it so, your observations are so casual that it seems that it doesn't affect anyone. थोड़ा बहुत कुछ गलती हो गया है. How much it is entailing upon a litigant or a petitioner, that perhaps you are not able to contemplate. Ease of doing business, this state government, central government, the whole world is talking about that. And is it the way you effectuate ease of doing business if you do not follow a procedure by law? You tell your officer to be present. Who is the concerned officer who has passed this 13th August order?
He will be the Assistant Commissioner of State Tax, West Circle, Ranchi, respondent number 4. Name was shown as Hadir Prashad.
So this is from Ranchi.
Yes, West Circle, Ranchi.
Learned counsel for the petitioner, Mr. Sumit Barodia, has referred to Annexure 19, the summary of show cause, no, it's, the intimation under section, what is called statement of tax.
Intimation, not a
Intimation of tax ascertained as being payable under section 73 within bracket 5 plus 74 within bracket 5, read with rule 142 1A, issued under form GST DRC 01A, and submits that no proceedings have been initiated by issuance of any show cause notice contemplated under section 74(1) of the JGST Act for imposition of tax, interest or penalty upon the petitioner. He submits that instead, इसका date दे दिया 29th January 2000. Instead, a summary of show cause notice was issued on 29th January 2020.
Summary of show cause notice is 14th March 2020.
Sorry, 14th March 2020, which relates to the set period 2017-18
And second case is 18. Same identical fact, 1819.
and 18-19 in the respective writ petitions. Petitioner asked for time to file reply on 17th March 2020. Stop. Thereafter, the lockdown intervened due to COVID-19. Stop. The certified copy of the order sheet of the proceedings at annexure 24 shows that after 14th March 2020, when the summary of show cause notice was issued under DRC 01, the next date is 14th August 2020, when DRC 07 has been ordered to be issued. That is summary of the order. Stop. Later, through counter affidavit, respondents have brought on record the adjudication order passed on 13th August 2020. Stop. DRC 0, which doesn't find any mention in the certified copy of the order sheet. Stop. The DRC 07 was issued on 11th September 2020. That is at annexure.
Annexure 23, page 190.
At annexure 23, which refers to the order dated 11th September 2020, imposing huge tax, interest and penalty to the tune of
In this it is 182 crores.
this last column, total one.
That's really ascertained from the adjudication order itself, sir.
Has been imposed. Whenever the figure crosses 1 crore, na, I am not able to because in our school days also the maximum which used to be asked, इकाई दाई सैकड़ा हजार 10,000 लाख 10 लाख करोड़ 10 crore up to the maximum 10 crores.
One day, but I was just ascertaining the matter just incidentally, it was around 6,000 crores and all. I literally told my junior that even they give me 0.01% of it, I will be happy, I will be retired in my life. इसको figure को जोड़ेंगे कैसे?
So
Calculator में नहीं आता है.
if the total tax engrossed in litigation is computed from the offices of tax practitioner,
Yes.
then alone that will give as to how much is the tax revenue blocked in litigation.
Yes, it will show that. It will cross the GDP of it. Remember in the first matter it is 182 crores, second matter 216 crores. They are
182 crores.
yes, in the first and second
The
216.
total tax liability as per the demand raised by the impugn order passed in the respective writ petition is to the tune of rupees 182 crore and 216 crore respectively. Stop.
उसमें भी एक ही common order की बात करनी है. For two assessment years. The respondent adjudicating officer has neither issued a show cause notice as contemplated under section 74(1) of the JGST Act, nor given any opportunity of hearing as contemplated under section 74(4) 75-4
of the Act, and the manner in which the proceedings have been held, which are in teeth of the judgment rendered by this court in the case of NKAS versus this private limited versus state of Jharkhand, reported in 2021 VIL. What is this VIL?
that we are online.
VIL 732 JHR capital. Stop. The manner in which the proceedings have been conducted show that the orders have been antedated and there is no sanctity attached to the presumption relating to regularity of official proceedings. Stop. Land counsel for the petitioner has also sought to draw attention of this court to the proceedings preceding to issuance of GST DRC 01A and DRC 01 when petitioner had been asked to produce documents in support of the transactions for availing ITC under section 71 of the JGST Act, such as annexure 12 and 13, such as 12 and 13. Learned counsel for the state has endeavored to defend the action, defend the order passed by the adjudicating officer. Stop. However, the certified copy, the order sheet, the entire order sheet of the proceedings have also been brought on record by the respondents through counter affidavit. Stop. The order sheet doesn't make any reference to the adjudicating order passed on 13th August 2008. Stop. The respondents have not denied that no notice under section 74(1) was issued before passing such adjudication order. Stop. The respondents are also not in a position to explain as to how the date of order in DRC 07 is shown as 11 September 2020, when the order was passed. If the order was, adjudication order was passed on 13th August 2020 itself. Stop. All these instances in a proceeding having serious adverse consequences upon a registered person registered under the GST Act. क्या लिख रहे थे? When such
All these instances in proceedings having serious adverse.
All these instances do point out to serious lacunae in a proceeding conducted under the JGST Act, which ultimately has entailed adverse consequences upon the petitioner. Stop. As such, we deem it proper to direct the respondents number 3 and 4
You cannot let it, respondent number 1 come who now the commissioner is the CEST officer.
We will take care of that. Respondent number 3 and 4 appear with the complete records of the case on the next date. Stop. Let the order be communicated to the Secretary, the Commissioner, State Tax Department. Also, so that the matter can be looked at from the level of the Commissionerate, as it reflects on the manner in which proceedings under the Act are being conducted. Let's close the case on Monday.
But they are insisting on that when the matter came up, we mentioned the matter. On 8th it was listed, they have started pressurizing me for payment from 3rd onwards.
So Monday.
They were not, so they should not.
Let's the case on Monday. Monday को physical है ना? Monday 2000 and that is 14th March 2015. Huh?
50 नहीं हो जाएगा.
Who is interested?
No, we are not interested.
So say so very loudly.
I am
Otherwise,
saying it very, very loudly, Lord, that we are not interested. Why, Lord?
in March,
Working till Thursday.
and March,
March is there. Supreme Court is working till Thursday.
Yes.
Or the other high courts are working on till Wednesday. Sorry, I am otherwise wrong.
so Monday. The concerned officer who has passed the order, will he appear or he is a transferred person?
So
ask the author of the order also to appear.
Yeah.
If the officer who has passed the order should also appear in case the officer, in case the incumbent of the office of respondent number 4 has been transferred, the author of the adjudication order has been transferred to some other jurisdiction, he should also appear.
May I mention 4 matters because these are toll tax matters. In Jharkhand now what they have done is they have issued a toll tax notification, amendment in the rule, which is separately being challenged, that in the nature of toll tax and additional tax is being levied on all mining bearing vehicles, which is directly in the case of several Supreme Court judgments that you can't take toll tax as in the nature of a tax. It has to be quid pro quo. And so these matters will be filed it now, it is ready. 2 matters are listed for defects today, will remove it. And if the learned court master Mr. Tiwari ki only indicate file doesn't come out. These are filed long back. Some urgency may come up on Monday. These matters. Because now they have given letters that we will block.
Have you mentioned earlier or today for the first time?
First time I mentioned because we are trying to get the matter ready. There's some defect.
So, if they are ready, or otherwise also you give this list.
I give this list, but it can be only indicated by the learned court master, then they send the file for removal of it. Some minor, some defect would be there, which we are unable to remove.
Have you applied for inspection to remove the defects?
No, the first time we can't apply for inspection.
Has it not been posted before the Lavajima also?
No, it has not even come after filing for the first time. 2 matters, that's the time gap which is happening, which is a lot of time gap.
And when have they been filed?
But they have been filed at least 10 days back. 10, 12 days back. In fact, day before yesterday, midnight, at
yes.